Good evening, everyone. Namaste. Welcome to the first online study circle organized by the Adhivakta Parishad, Delhi High Court Unit. Usually, we would meet everyone on a Friday at the Delhi High Court premises. Our sessions, which have been happening for the last 10 years or so, have taken place at the bar room opposite court number 35. Now, because in these unprecedented times and unexpected times where we don't know where we are headed, however, we should not grow apart of each other. The legal fraternity should stick together and come close than ever before. That is why we thought we'll take this initiative of organizing our first online study circle with a very well-known legal luminary of our fraternity, Shri Aman Lekhi, who's with us today. We've had this privilege and honor of hosting him on our platform. Throughout these 10 years, we've had various legal luminaries who've come and graced us, addressed us on various legislations, policies, rules, procedures. And in this technology age, in this information age, we would just want to take it further ahead. So we welcome lawyers, we welcome professionals, we welcome students, teachers from across India, because the power of internet is such, there is no boundaries of space or time or location. So we are joined here from people across India, across all corners of India. And before I have Sir on, just a brief introduction about Sir I would like to give. We are today discussing two topics, which is one is about virtual hearings. There is a lot of talk going around as to whether virtual hearings is the way to go about things. And Sir has had an experience of attending webinars and video conferencing in the Supreme Court. So we would like to hear Sir on that. And second issue that we would be discussing is the force majeure clauses. And there is a lot of talk, a lot of companies have had this doubts, clarifications, and a lot of advisories have gone out from a lot of law offices about force majeure clauses. So we'll come to that later. As we all know, Sir became a senior advocate in the year 2005. He was designated. Very recently, he's been involved with extremely important constitutional matters. As recent as in March 2020, he was part of the Madras High Court judgment about the functions of the Honorable Governor of the Union Territory of Puducherry. And that appeal was allowed by the Madras High Court, and Sir had appeared for the Union of India in that appeal. Apart from that, he has appeared in cases involving the appointment of the naval chief, in which he got a favorable order for the government. And some other cases also. Very recently, he was involved in the Calcutta High Court order about e-cigarettes, where the ordinance that was passed by the government of India was upheld. And he has also appeared in the VVIP chopper scam, wherein an anticipatory bail plea was filed, and Sir appeared on behalf of the Enforcement Directorate. And also a case challenging the operability of the NIA Act. Sir was also appeared there. So Sir has been appearing very regularly for the Union of India as in capacity of being an additional Solicitor General. So we would like to hear, Sir. We would not like to keep all of you waiting. So Shri Aman Lekhi, Sir, I welcome you to Adhivakta Parishad. On behalf of the Adhivakta Parishad Delhi High Court Unit, I welcome you. So let's begin, Sir, on about the first topic, which is about virtual hearings. If Sir could address us.
Yeah, Shimendu, thank you so much, and thank you for inviting me. I think it's a very laudable initiative, as you very correctly said, and something which will, in many ways, augment our knowledge about things which are very topical and relevant. Without wasting any time, I just want to I don't want to preface what I'm saying by just telling, without acting as a killjoy, the enthusiasm which is there where virtual hearing is concerned, I am not going over the top where this particular facility is concerned. And the reason for my not going on the top, and for that matter, thinking some kind of magic bullet, is because a realistic assessment cannot but acknowledge the existing state of our legal infrastructure. And any kind of technology has to fit the infrastructure, and the infrastructure which exists has to be adapted to use it effectively. And while much has been said, in most cases laudatory and not without justification, that yes, this is technology which can improve the justice delivery system, there are various pressing issues which I feel have not been addressed or acknowledged while promoting this method as a means of legal problem solving. And why I say so is, I talked about the legal terrain. The sheer logistics of it is something which is very daunting. And why do I say it's daunting? Because we are talking about virtual hearing the trial court. This is actually the topic here. And if you see, as far as the legal system is concerned, how is it it's going to work? I mean, one part of it is, yes, it saves time. It will facilitate a seamless communication. It will save costs. Yes, this is something which is repeated continuously, and ad nauseum we are hearing various people talk about it. But there's a flip side to it which cannot possibly be ignored, and see where it functions, because we have ideas in our mind of systems very different, like Canada, South Africa, Australia, systems which I'll come to later, systems which are very different from the Indian system, and where we cannot replicate the kind of method that they have. Even Singapore, I'll deal with Singapore later. Why I say so is, and please don't get me wrong, the purpose is not for me to say to dump this technology altogether, but point is for us to be aware as to how is it we have to use the technology, and so that it is relevant for us. And if you look at it, if you see how many cases are there in the trial court, there are about 3 crore cases right now pending in the trial court. There are more than 15,000 courts, more than 3,000 court complexes which are there. Now, as far as technology is concerned, this technology has to apply to this situation. And it's applied to this situation when, very importantly, we have only a fraction of the GDP, which is used for the purposes of judiciary. In fact, the national average is 0.08%, is the national average where that is concerned. And when you talk about technology, and that too virtual hearings, which entails, of course, investment in fiber optics and high-speed cables, etc., apart from the other aspects whatsoever, the expense which is to be involved, apart from the fact that its effectiveness, where this system as such is concerned, will come later. How is it that from where will we get the resources, and whether we have a plan in mind for the purposes of our using these resources, and we have only a fraction of this of the financings available actually dedicated to judiciary. This brings me to the first point. There has to be a change in thinking. You just can't look at this and say, okay, wow, we got something new. And because we got something new, there's a lot of excitement about it. But we can't go over the top where this is concerned, because we have to be realistic what this is. The first thing is, have you thought about how is it that we're going to effect this by keeping apart a substantial chunk for the purposes of financing this activity? This is number one. Number two, this, so far as this aspect is concerned, it's not just money alone. If you look at our system as such, whether it is a judge population ratio, something which is very much talked about, I don't need to delve into that much, because we got one of the least in the world. Apart from the fact that there's the death population ratio itself is poor, we have an ancillary issue of the number of judicial officers, again the trial court, being less. That is, the existing strength is less than the sanctioned strength. And not just the judicial officers are less in any case, the facilities which are there too for the judicial officers are also in many ways inadequate. The Supreme Court receives this particular matter in any case, and there's augmenting of these particular facilities. This becomes the second point which has to come in, that when we are dealing with this, the people who have to work it, that is the availability of both the physical and the human resource for the purposes of working the system, has also to be kept in mind. So this is the second thing which you have to do for the purposes of overhauling the system and upgrading it for the purposes of having these available for this particular purpose. Number three, as far as this issue is concerned, equally relevant here is, we had a very ambitious program, that is the E-Code program. And if you look at the order of the Supreme Court of 6 April, it refers to the E-Code program too. And it talks about the E-Code program in rather complimentary terms, that it should. It is a very ambitious program, a program which actually opens the vistas for the purposes of changing the landscape whatsoever of our legal system. But the point is that this program, which actually started, and it has over a 3-year phase, 2007 to 2011. The first phase was 2011 to 2015, and second phase was 2015 to 2020. Apart from the fact, and it has made substantial progress. Yes, there's been certain changes that brought about. But as far as the changes are concerned, what is what the primary change which has come over here is that we have a system of video conferencing. Video conferencing, which is exciting all of us a lot these days. But the video conferencing which we have is actually limited to a very niche kind of hearings, and rightly so, which I'll come to later. You can't possibly have video conferencing for all kinds of hearings. So you got video conferencing for, say, remand, or for the purposes of examination of witnesses, recording of evidence, etc. is concerned. That is primary use of this particular exercise of the e-courts which has come, apart from the fact that we got the cause lists which are there on the net, and of course the orders, and a large number of orders. The orders are running into crores in numbers. The number of orders which are there, which are available online for the purposes of access to justice, for facilitating, say, the policy making in this is concerned. But this is not something which is equipped adequately to deal with the question of, say, video conferencing, or moving forward to have effective court hearings virtually, to have virtual court, which you are actually concerned with. Because you can't have virtual court simply by plugging a computer, having people, and then speaking to it and feeling very happy that we spoken something, we saw ourselves on the screen, we have people without on the other side with whom there's a fair amount of distance, you don't need to actually travel there, and we can conclude it in a short period of time. But the very thing which make it attractive also have the limitation which is actually absolutely implicit in it, because it's not, as far as video conferencing is concerned, video conferencing would require one, along with this particular thing, digitization of records. Now, digitization of records is something which cannot possibly be ignored, and that digitization has to be from filing to disposal to archiving in any case. So this brings us to another issue. Where are we when digitization of records is concerned? That is, if you want to have virtual hearings, you need to have paperless proceedings. And for paperless proceedings, even the Supreme Court, we got e-filing over here. You have to file hard copies in any case. If you file hard copies in any case, that means you have in the back of your mind the fact that, yes, where we are concerned, this particular e-filing system may not by itself address the issues which we may confront. And there's a need, therefore, for the purposes of there being some kind of a physical backup for the purposes of having this particular thing. Now, keeping all these things in mind, what we have to see is that this is a question, not simply, as I said, of having a computer screen and talking to it as we are talking now, because this is not like this webinar is a very simplistic way of actually interacting, because here you have me talking and anyone listening in any case, but just multiply this into 3 crores and bring in cases, and then bring in case materials, and bring in the lawyers, and bring in multiple lawyers, and then bring in the judges too, and along with the judges bring in the witnesses also. Now, in this system, this method through which we are communicating, by which we are actually talking, how is it that we are going to work it over this period of time for the purpose of accommodating all the stakeholders in the system to have some kind of meaningful and effective participation in it? Because for adjudication, participation is very important, and not just actual participation. A feeling of participation is also to be very important, and the both actual participation and feeling of participation is actually very, very material for the purpose of efficacy of this particular system. So what is necessary is that we have to not talk only of this. You have to talk about, say, the designing of the system, and the designing of the system will also require re-engineering of the way in which it has to work. And for re-engineering of the way in which it has to work, we have to bring in the IT, we have to bring in the HR, human resource people also. So it has to be a combined effort to suit what is actually our existing legal system for the purpose of having this particular facility as being actually useful for the purpose of justice delivery. Now, I talked about the e-court program, and that's why I talk about the e-court program, because the timelines are very important. Now, if you look at the timelines of the e-court program over the period, as I pointed out, from 2011 to 2020, all we have here is we got the case cause list, you got the judgments, and you got limited use of video conferencing. Now, what has happened this particular time? Let's say what has happened elsewhere where this is concerned. I give the example of, say, Singapore. And so Singapore is concerned, because that is very important, because we have to place things in perspective. Singapore is not the ideal comparison for India. In fact, for comparison, India is concerned, I don't think there will be any legal system, because we got a very robust legal system, which does not have a parallel, and a system which actually, as a judicial system is concerned, a very well functioning legal system, which is notwithstanding all its inadequacies, notwithstanding all the problems, a robust legal system which is doing very well. But nevertheless, because we talk about virtual hearings concerned, that's the reason I'm saying that In Singapore, there was a system called EFS, electronic filing system. Now, electronic filing system was then replaced by what was called an integrated electronic litigation system. Now, electronic litigation system was an improvement of the electronic filing system. Electronic filing system was in any way a system much better, far superior to the system which we have in the e-court system. The e-court system in which we don't have possibly case management, we don't have judicial management, and we have got absolutely no facility for virtual hearings. Now, this system was already in place, and the system which was in place was improved, and it was improved from being fact specific to case specific, and it was an integrated program involving the law firms, the lawyers, and the judges, so that the front and the back end actually corresponded, and the system worked on the hearing for accessibility to the documents, for access also to the legal material, and eventually fixing the dates of hearing and actually having the hearing. And the system was in place. And the system was an improvement over the electronic filing system which was there earlier. And we, despite having a dedicated program, even as a pilot project for say a limited number of cases, for a particular number of courts, for a specific type of matters, were not able to devise, and we did not devise something which could be more or less parallel, despite the fact that there was a system also in place over there. Now, Singapore is not the only.
If I may just come in, there are some comments that are coming in.
Yeah.
So if I may just put it out on screen.
Yeah.
The first one is from Mr. Kohli. This is on the YouTube channel. He asks that virtual hearing concept is very good and is a need of the hour, but how, with utmost sincerity, can we deal with witnesses? So before you answer this, may I just also request you to, if you can just take the camera, if you could just shift your camera, because yes, further, sir, further. I think this is better, sir. Thank you so much. Yes, sir. So this is the first question that we'll just take up, then we can continue.
Yeah, this is a very good question, Pradeep. I was to come to it eventually, but I'll deal it immediately. That's the point I'm making. As far as witnesses are concerned, there are various issues which come over here. Witnesses are concerned, as the logistics of it, in any case, considering number of cases which we have over here. And apart from witnesses, insofar as when you talk about cross-examination, the various aspects which come along with the cross-examination, apart from confronting a witness in any case, which will require, as I said, digitization of records, or at least existence of a file which is more or less the same on both sides of the screen, with everyone on the same page that is concerned. One. Two, and like in criminal matters, we have the issue as insofar as the sealing of a document is concerned, or sealing of an object is concerned. Now, what is very important in these cases is the seal intact, or is the seal there at all or not? Or look at the seal, is the seal the same at all or not? So for that itself, we need to have a camera. Apart from the camera, and there has to be someone to actually look at the seal, and not only look at the seal, then to examine it for that particular purpose, and then conclude whether, of course, is the seal the same, or the seal is intact at all or not. Or give another example. Insofar as the witness is concerned, and in the course an issue crops up, the case diary has to be seen. The case diary is the police fan. The court has got access to the case diary, but where is the police fan? Is the police fan where the court is concerned? With the court or the police fan the same place? And even if they are the same place, you can anticipate whatever it is. How is it that the logistics of it is to be, in any case, dealt with? And then multiply this into 3 crores, or multiply it, say, 2 crores or 1 crore. Now, how is it that you are going to have this particular system in this particular case? And more importantly, the biggest studies. The studies over here, which actually say, Harvard has done some studies also, actually say that the way in which the camera is placed also has a very important role to play as to how the mind is to be affected. Because the placement of the camera itself can in some way exude some kind of image. And when you're talking about criminal trial, the trial as such, not as criminal trial, image is very important. Because no matter how objective the judge may be, and no matter how dispassionate they may seem to be, and so what the method of dealing is concerned is some way subjectively influenced by prejudices. So various issues have also cropped up with that is concerned as to how do you place the camera, how do you dress up with that is concerned, in what way do you show a witness actually involved, the sound quality, how audible it is, and so on that is concerned. Is it clear? Is the technology which is being used at both places, the place where the judge is sitting, the place where the lawyer is sitting, the place where the witness is concerned, are the facilities the same in any case? How do you regulate that particular mechanism? Now, all those things require a very detailed infrastructure which has to be there, which we must actually work on to make it effective.
Yes, sir. So the second question that we'll just take up, privacy of parties also becomes very important.
Yeah, privacy of parties, not only for encryption. I was going to come to that. I'm very good with this. We got a very intelligent audience. Now, privacy, Rachita is absolutely correct, is concerned. There are two aspects of it. One is privacy, and the other is security, because the question actually combines the two. Security is something which you have to have firewalls, you have to have systems in any case to ensure that insofar as the link is concerned, that link remains secure, the link is not breached in any case, and there is no unauthorized intrusion into it or distortion of it. That is the security aspect of it, and so where that's concerned, that has been actually designed also with a fair amount of circumspection intelligence. The other is the privacy. This is again something which has actually engaged the attention of many people here. It's engaged the attention of people because in say criminal hearings, the person is accused. Now, as far as these hearings are concerned, as long as the hearings actually are confined to the parties over there, because everyone is knowing the identities of each other, this can have bearing also on the privacy issue of a particular person, particularly if you deal with the fact that if you extend virtual hearing to say live streaming for the purposes of addressing what is called the theory of access to justice and open hearings. I got very strong reservation that is concerned also. I mean, I don't endorse live streaming as some kind of panacea to deal with all legal problems, as to be some kind of check over what's going to happen, because live streaming also has got its limitations, because I personally feel where, as I always say, judicial proceeding, judicial review is counter-majoritarian, and because it is not something, we don't have judges who are elected, and for good reason we got that, and we have to insulate judges also from this kind of popular pressure, or this, which in grandiloquent terms may be called tyranny of the majority or tyranny of the most vocal. I will not call it tyranny of the majority. So all these things have to be kept in mind. You have to decide upon who, when, what kind of matters. You can't have it across the board. All kinds of matters cannot be done.
Yes, sir. So, Mr. Rao.
Question.
Yes, sir.
Yes,
So
absolutely.
Yes,
the demeanor, now for demeanor, there are various guidelines in place. What can normally happen is that there should be a person on both ends of the proceedings, and a note should be made with the demeanor. A note should be made with the demeanor. There can be a point person where the witness's statement be recorded, and there can be someone on the other side where the judge is concerned. And the demeanor is concerned, the record can be contemporaneously made by whoever is participating in the proceeding. It's a very important question, Mr. Rao. This is a question which is very material in these matters. But for that, they need to have a contemporaneous record, the demeanor, which can actually be made part of the proceeding as such.
right, sir.
Should I then move forward, because I was on the other systems?
Yes, sir. Yes, sir.
Now, we talked about, I mean, that's why these questions are very pertinent, because they actually open the issue up altogether, and this is something which we have to in many ways look at. Now, similarly, you see, we have in the Federal Code of Australia Act, the Federal Code of Australia Act 2 has got provisions for virtual hearings. But what is very important is you have to learn something from it. Virtual hearing, where that is concerned, is on an application, can be done suo motu by the court too, and you have to justify the need of those hearings. And it is only when those particular virtual hearings are actually suited for the activity, for the kind of proceeding which have to take place, and they have looked at the tested the equipment on both sides, the quality of that is concerned, the suitability, to what extent the documents, etc., are there. Now, it is only then that the virtual hearing. So it's not as if it's across the board. Virtual hearings in all kinds of matters, in every kind of case, whether there's need at all or not. It's not as if it happens over there also. Similarly, you have virtual hearings. You had virtual hearings in South Korea, which I happen to read about. And of course, everyone knows the Criminal Justice Act, insofar as the Access to Justice Act, the UK is concerned. Where again, as far as the virtual hearings are concerned, the virtual hearings are also not. They exclude criminal matters, essentially for case management or ancillary hearing or remote examination of witnesses, etc. is concerned. So when you talk about these virtual hearings across systems, the system, as I said, are very different to the system which actually we have over here, which have problems which are unique to it. And because the problems which are unique to it, the efficacy of this particular hearing has necessarily to adapt and adjust to those particular problems. And we have to then mold the system to meet it. And to mold the system to meet it, also you have to decide, one, what is the kind of hearings which you have to do? Two, what insofar as kind of hearings are concerned, you have the procedure, the discipline has to be, because you have to have a limit, a number of lawyers are going to speak, because it's not unusual to have multiple lawyers. You can have one case, but you can have one party and have 10 lawyers, and each lawyer will speak, because everyone has to be heard, because until you are heard, you're not going to get paid. So the kind of chaos can be managed in the courtroom, because you've got physical space and size, it is not an issue, and you've got indulgent courts. So we'll have to see how many lawyers are there. Number three, we have to prepare in advance. And so prepare in advance in two ways. There can be pre-court hearing as to how is it the proceeding have to take place. So for deciding how the hearing have to take place, you have to prepare in advance. Now, what happens here is you got the oral argument stream over here. Most lawyers who will argue over here will develop the arguments while they are arguing. It's not as if they will prepare the arguments prior, confine themselves to the points they made, and then speak it. So a point strikes us, and we just say it's a good point, and because we are not bound by any discipline, we will speak to the court. Now that kind of facility will not be there because the documents will have to be digitized. Availability has to be there. It should be known in advance what's going to cite in each other. So you have to have some kind of agreement as to what is it that you're going to argue. That is, there should be some exchange of as far as written arguments are concerned. What you're going to argue. Then there has to be also an agreement as to what documents. There has to be something like a convenience compilation, which is over there. That yes, you're going to have like these documents only, or these relevant, these issues only, which have to be there in any case. So this is where final arguments are concerned. It may be used in final arguments, in limited number of final arguments, where these particular issues can be dealt with. Its suitability for trial has got its own limitations, requires something which will actually be thought about with a fair amount of sincerity. And so far as bail is concerned, you can hear this kind of matters today. These days you're hearing bail and other kind of urgent matters because you're hearing one matter at a time. And it's only at the discretion of the court as to which matters to be heard. And the kind of multitudes of cases which is over there, and so the volumes of matters which are there, which is current in the legal system is not there. So you got a system which can manage it. But just imagine a scenario where the system is the way it is, then we go to court. So the number of matters which are there which we actually handle, and then see, have a reality check, take a step back, take a deep breath, think, and then apply that. Yes, we got this technology. This technology has got its merits, but this technology which has its merits and is available, to what extent can this technology be used? Where it can be used? How much money we have to use it? And insofar as the courts are concerned, are we in a position to connect the courts with it? Because it's not just the camera or anything else whatsoever. There are various issues along with it. Apart from the fact that you got equipment over here, you need electricity, you need to have internet, you need to have quality, you like to have education in some cases where this particular issue is concerned. All these things have to be taken into account where this is concerned. And just can't say that, yes, now we got this. This is so far as the solution is concerned, the solution is there for dealing with it. No, quorum non juris is not something. It's this is as something a matter of levity. Yes, insofar as quorum, because if it is part of, if rules prescribed for a virtual hearing and the methodology is actually decided as far as virtual hearings are concerned, has been done in an exercise that part of the Supreme Court has extended the 142. There's absolutely, so the jurisdiction is concerned. The jurisdiction is there. The hearings are procedurally mandated. There is substantive law behind it. The methodology and the application of law is known. The parties are following a protocol which is well settled, and the capacity of the courts to deal with it should not be doubted. If I'm not on the issue of quorum non juris at all, there's no requirement of quorum non juris over here. Where this is concerned, of course, there will be amendments or rules which have to be done on a permanent basis for the purposes of legitimizing whatever procedure is there, so that should there be any challenge to this particular method, which I think would be far-fetched, too remote, and completely unwarranted. My problem is not with this question of quorum juris. My problem is something far more substantial, serious, and far-reaching, as the efficacy of this particular system, the existing scenario in which we are working.
Right, sir. We could also move to force majeure.
Yeah.
We could also move to force majeure, and then maybe people have questions. We can come back to that subject later as well.
Yeah. Now, force majeure. Now, this is a completely force majeure is again something which is much has been written about force majeure, and as a term, which is something which I must commend you for choosing this as a topic, because something that has to have clarity. Now, what is force majeure? Now, force majeure, what is important is that I will not go into definitions because it's something which is impasse. Force majeure should not be considered as a French version of vis majeure. That is standard. Now, vis majeure is an act of God. Force majeure is something which is far greater. That is something more than act of God in any case, is something more. The point is that as far as this question is concerned, it is basically a term or a clause by which a party or both parties can be excused from either fully or completely performing the contract, or to suspend the performance of the contract, or extend the time within which it is to be done. It is basically, essentially, it is a clause in a contract which actually is force majeure. And in far as force majeure is concerned, it refers to circumstances which are independent of the will of the person concerned. That is very important. That's not something. We have a force majeure clause. That is a clause which can in some way suspend or extend the performance, prevent or to excuse any prevention or deterrence. I'll deal with these aspects later. But the condition precedent is it should be something beyond the control of the parties where this issue is concerned. And the event should be one which is very important, should be one which should have been in the contemplation of the parties at the time this actually happened. Now, this is very material because force majeure is usually used interchangeably with frustration. And even Supreme Court judgments, I will not go into Supreme Court judgment by reputed judges, and ever and counsel, in any case, have often used the expression interchangeably. But force majeure and frustration are two distinct and mutually distinct things, and the distinction must necessarily be kept in mind when we deal with this issue of force majeure. So it's basically a clause which can in some way excuse the suspend. Excuse the suspend because the circumstances beyond the control, and circumstances beyond the control should be nevertheless those which should be in the contemplation of the parties. And when you're dealing with the force majeure clause, this comes the next thing, or how do you interpret a force majeure clause? Now, when you look at a force majeure clause, don't look only at the force majeure clause. You look at a clause, you look at the wording of the clause, you look at what precedes it, you look at what follows it. You look at the scheme of the agreement itself, look at the purpose of the agreement itself, and then you place a force majeure clause in it. Don't look at the term of the force majeure clause only. See it in the context, the setting, for the purpose of actually finding what the meaning, because the meaning which has been used, the word which is over there, can be in some way influenced or colored by what actually surrounds it. And that is actually the basic principle of interpretation of context which you have to actually see. Now, when you deal with this, what is necessary is what is that you have to consider while dealing with force majeure clause. One, how do you define it? That you must define it with precision. This is because we don't have to. You have to define it with precision, not only because only then you have an efficacious force majeure clause, but unless there's this definition with precision, there will be the contract itself will avoid uncertainty. Number two, you have to absolutely set out the effect. What is going to be the effect of it? And this is where force majeure will be different from, say, frustration, because as the force majeure is concerned, it can say, okay, I'll give you more time, or we'll suspend the performance for a particular point of time, and we can watch for a particular period of time. And termination will not necessarily follow. Termination will come eventually, but it will not necessarily happen of its own. And that is where comes the third aspect of force majeure, apart from the definition and the effect, that the process, what is the method by which it's been worked. And this method is also very important because, as you all would be knowing, as the terms are concerned, the term can be a condition precedent or it can be intermediate term. Now, if it's a condition precedent and it is worded as a condition precedent, for anyone to actually invoke the force majeure clause, you have to actually strictly follow the method which actually means prescribed. Well, unless you follow the method which is prescribed, your capacity to actually invoke the force majeure clause would to that extent be affected. But if it's an intermediate term, it's an intermediate term in which, in fact, you cannot possibly make the invocation of force majeure conditional upon that particular exercise. In that event, merely because you not strictly follow the way in which it has come, will not necessarily affect this particular method of invocation of the force majeure clause. Now, while dealing with force majeure, I already began by saying that so far this is concerned, it is different from frustration. I'll deal with that later. It's also important to know that a force majeure is not an exemption clause. This is another thing which has to be kept in mind, because there's some kind of similarity between a force majeure and an exemption clause, but there is no identity between the force majeure and an exemption clause, because what a force majeure does is important. To be put it very simply, the force majeure clause qualifies what is actually an absolute obligation. Instead of providing what will happen in the event of a breach. That is very material, because you say, I promise to do this thing if this happens. So you qualify what is done. So it's not an absolute obligation. The obligation, I'll be exempted from doing this in these circumstances. So it's not an absolute obligation. It's a qualified obligation. Because a qualified obligation is in terms of, it is in the way in which the contract clause is worded. Because the contract clause is worded, therefore force majeure goes to the clause in the contract itself. And because the clause in the contract itself is different from frustration, because that deals with some supervening circumstances beyond the contemplation of the parties which is over there. So it's not an exemption clause. It's got some similarities to exemption clause. It's not frustration. It may have the consequences the same as frustration, but it is absolutely distinct insofar as these aspects is concerned. So you have to see it is different from frustration. It's different from an exemption clause. It's actually a clause in the contract, circumstances because of some supervening, because something which is not in the contemplation beyond the will of the parties concerned. Now, insofar as first page is concerned, what all do you have to keep in mind? One, there's something called what is called triggering event. And so that will be, insofar as the clause is concerned, you have to set out what the triggering event should be, insofar as you have to specify out, and that is where the difference between the which major and a force major comes in, because as which major is concerned, the which major is basically an act of God. Force major goes beyond, goes to inundations, it goes to wars, it goes to strikes, it kind of administrative, litigative limitation, etc. So it was far wider in its ambit. No, yes. Now, this is a good question. COVID, please understand, COVID, but it not act on its own. The COVID it could be both act of God, but because COVID has been supplemented by various kinds of administrative diktats, they got some kind of laws which have now been invoked. We've got a National Disaster Management Act. We've got the diktats have been issued under the Act by the state government, by the national government, by district authorities only. Because we got these diktats have been issued which have in some way influenced freedom of action of people. And they're stopped. Like there's a quarantine, there's a self-isolation, there's a stopping of manufacture, there's stopping of movement. So transportation, storage, manufacture, everything is affected in many cases at all. And that is affected not only because of COVID. COVID is there, yes, but whether COVID was the reason at all or not, this is a legally sanctioned way in which certain actions have been prohibited or if not stalled altogether. Because this has happened, it can be a force major event, quite the clause actually stipulates for it. And even if it's a force major event in any case, when it's a force major event, you have to see what does the contract deal with it. Does it entitle you to void it altogether? Or does it in any way deal with it and so as to delay it, to suspend it? Because this is very important where this aspect is concerned. Thank you, Manisha. Where this is concerned, this is very important, but this is concerned as to how you are wording the clause. Everything turns on the wording of that particular clause. So I was on the triggering events, which is there. Right? So you have to see the triggering events which is there, which you have to identify. Then you have to say as to what's the triggering effects are concerned. There should be causal link. It's not that there be a triggering event. There should be a causal link between the triggering event and the event. So without a causal link, you cannot possibly have a force major clause. And I'll deal with it now that I'm dealing on the causal link. Like there's a case. I'll give you a simple illustration. Now suppose there's a contract. Right, and the contract talks about shipping of something, shipping of whatever is the contracted supply, and it's shipping of supply. Let's take fish, and the shipping of supply, and the contract says unless there's a failure to fish, failure of crop, or failure of whatever the product is concerned, there's no question of the force major will come on say a failure of a crop, which has happened over here. Now, supposing there is no failure of crop as such, but there's an increase in price because certain wartime inhibitions have been placed the way in which land is to be used, because it limits the area in which land is available and also makes access to the land and working on the land tough. Now, access to working on the land tough shoots the prices up. Now, it shoots the prices up. There's no failure of the crop. There's no failure of the crop, but insofar as the question is concerned, because the circumstances surrounding makes this particular question of growing the crop more expensive. Now, I say that growing the crop is expensive. This is something way beyond my means. Now, because it's way beyond my means, as far as this is concerned, therefore I will not do it. But is there causal link between what is stated in the contract and what actually followed? There is no causal link because the failure was to be the link. And here it's not a question of failure, the circumstances which is actually independent of the failure. So number two, there has to be some causal link between the two. Number three, what is also important is that as far as clauses are concerned, there is a difference between, say, preventing, hindering, or delaying. Now, the requirements of preventing and hindering, delaying are all very different. It's not as if in every case the legal consequences of which are absolutely the same. But when you talk about preventing the performance of the contract, and preventing the performance of the contract would be something which makes it a physical impossibility, or it makes it legal impossibility. The threshold is very high. That is something which it cannot happen at all. And so that is concerned. That is preventing what is actually stipulated. Now, preventing is different from, say, hindering. The threshold of hindering will be less, even if supposing I am not prevented altogether. But the working of the contract may be such that it may dislocate my system altogether, or there may be some string contracts may be elsewhere, which can be in some way affected in totality with the way in which they have to work with each other. And I cannot possibly perform one contract at the detriment of all the other contracts and bring this system to a standstill altogether. So while theoretically I may be in a position to perform this particular contract, but because the performance of this particular contract will put me in some kind of jeopardy where other contracts are concerned, and lead me into some kind of breaches where those aspects are concerned in any case. So that will be in some case hindering of the contract itself. Or it can be delayed. You can say, okay, as far as this is concerned, I'm in this problem. Because I'm in this problem over this period of time, because I'm in problems in this period of time, this should give me extension of time. The extension of time again will come in so far as the procedure is concerned. You have to word it in that particular clause for the purpose of dealing with that particular contingency, for the purpose of deciding whether a call it will be preventing or hindering at all of that particular contract itself. And these circumstances, as we say, should be beyond the control. It's not something that you just said, apart from the causal link, there has to be some circumstances should be actually beyond the control of the parties concerned. And most importantly, that as not only beyond the control, that there has to be an attempt at our end, at the end of any party which is invoking the force majeure clause, that any reasonable steps to mitigate the non-performance. It's not as if because they are in the realm of contract. And in the realm of contract, the bargain is supreme. And because the bargain is supreme, the contract has to be followed. And it's not a question of only a contractual liability, it's a question of, and there's got an ethical dimension to it also. You should be a man of your word. The promise should be worth the paper it is on in any case. And these clauses.
She's talking about defenses, sir. What defenses are available to
us? Defenses, the force majeure clause is actually the same thing. Let's say in the opposite. Yes, Sugandha. The defenses would be very well. These would be the defenses to be available. You have to say that one, depending upon what clause you're saying, you talk about preventing, hindering, or delaying. First of all, you have to see what is it, how is it been invoked. And you can then see whether the legal threshold for each is there. This is number one. Number two, what you have to say is that beyond the control. Number three, you can show that there is no causal link between this. Number four, you can say there was an alternative method. Or they could be, you did not do anything to mitigate whatever had to happen whatsoever in so far that is concerned. It's not something you invoke it. Number five, you have to say the procedure. And so, is it the procedure which is followed? Now, if the procedure is not followed, what is the point of a procedure? Why is the procedure prescribed in the force majeure clause? A procedure is prescribed in the force majeure clause so that you can put the other side to notice as to what is it that you're going to do and justify your doing it. So that if you put it to the other side and give an explanation, the other side is then put to notice of your defense for you to meet it and contest it. And when you contest it, you can show that, see, your reliance on the force majeure clause is misplaced because the circumstances do not attract the force majeure clause. Because the force majeure clause is basically a term of a contract, and the way in which the term is drafted, keeping in view the principles on which force majeure is based, you are not entitled to invoke the force majeure clause at all or not. So much as a person who's invoking a force majeure clause has got a fair amount of options, legal options available to him for the purpose of invoking a force majeure clause, and so as the person contesting a force majeure clause is concerned, that person concerned is also have that particular options. Now, while this is concerned, we have to deal with this force majeure clause is concerned, which is something which is often missed is we have certain specific events which are there in the force majeure clause, and along with the certain specific events that are there in the force majeure clause, we got a general, all-embracing, all-sweeping residuary clause, and say anything else of similar nature or something like that, which normally comes over here. Now, how is that to be interpreted? Now, there are some judgments that say, that as far as the issue is concerned, these clauses have to be construed narrowly, broadly. Now, don't go by these words. Narrow, broad is not. It's not a correct description. Much like interpretation of statutes, a strict construction is a thing of the past. Now, look at the clause at this and look at the scheme of the act and see what is the meaning. Because the question is, what's the meaning? Narrow, broad is irrelevant. If the meaning comes narrowly, it's a narrow interpretation. If the meaning permits a wider interpretation, wide interpretations don't have this preconceived notion about narrow or broad. Look at the clause for the purpose of deciding what it is. Now, when you look at this particular clause, you have to see, did the party have in contemplation the event in question? Now, if the party could not have in contemplation the event in question, no matter how broad that particular clause would be, that will not be part of the force majeure clause. So it will not be part of the force majeure clause. Why? Because the force majeure clause is a contractual terms in which prior to what is happening, the parties agree as to what is going to happen in the event of there being a situation like this has actually come up. Now, that is in that event, what is important is that if suppose it is not in it, then the question would be, it is a question not of force majeure, but it will be one of frustration, provided the conditions of frustration are satisfied. If not, as a Majeure clause, it is not there, therefore it will be frustration, because frustration also has got its own discipline. So when you're dealing with these larger words, which follows the specific word, that the triggering circumstances is over there, what you have also to see, and that will also be important when you talk about defenses or to a force majeure clause, was it in the contemplation of was it in the contemplation of the parties at the time this particular event, because it has to be in the contemplation of the parties. Yes, there have been certain, if you look at Chitti in one portion of his book has referred to some judgments which actually disagree with this particular issue and say, and the expression which is used there is essentially that a party cannot be made liable for a party's improvidence. This is what Chitti has actually said. But even that being considered, whatever the improvidence of the party's wording is concerned, keeping in view the distinction which is there between frustration and force majeure, unless you can actually show that yes, this was in the contemplation, that will actually leave a window open and allow access of foothold to a person to actually distort the bargain. And distort the bargain by bringing into it circumstances not in the contemplation so as to defeat the agreement as altogether. So it's very important to know how the broader aspect, because the things are not normally generally missed, how the broader aspect of that force majeure clause has to be seen. This is also very important, relevant both to the person invoking the force majeure clause as also the person actually seeking to defend what the force majeure clause actually is, as far as this issue is concerned. This is also, you had something to ask me, Surendra?
Yes, sir. So there are certain questions coming in about contemplation of the parties, because we are on the subject of contemplation of parties.
Yes.
Now, nobody saw COVID-19 coming, nobody saw coronavirus coming.
No,
so that should be related only with the particular force majeure clause, or it should be even more specific as to mention what particular events have to have happened. Should it be defined? If we could discuss.
Probably standard force majeure clause. I'm just talking about situation because we are in this, you have to contemplate. Point is, in law, we have to be clear in concepts. Once you are clear in concepts, then wording becomes very simple. And not only wording becomes simple, our understanding of wording also becomes simple. So we have to go to the basics of it. You have to understand. Now, to deal with the situation, supposing the clause uses the word epidemic or it uses the word pandemic. Now, as that question is concerned, epidemic being there, you don't need to mention COVID. Epidemic is there, pandemic is there. I'm talking about situation. I'm not talking about the triggering events. Please understand, I made a distinction between triggering events and the general words. If a pandemic is mentioned or epidemic is mentioned, that is a specific triggering event. If a specific triggering event is there, then on a literal reading of the contract, it will be covered by it, subject to the discipline of the clause as to way in which it is being interpreted. What I'm talking about are not a specific triggering events. I'm talking about a general word which follow the triggering events. And because it is in the ambiguity of the general word that the honesty or dishonesty of a plea will be tested. And if this is the clause which has to be actually examined, then insofar and the invocation is to be in something justified, then it has necessarily something which the parties had in mind when they actually did it. Because it can't be a catch-all phrase for every kind of problem which a person actually seizes for his benefit ex post facto, because that is not something which will be within the ambit of a force majeure clause or whatsoever. So it is only if this is so that when whoever is watching this and looking into it, thinking about it, when you look at it, you have to see what is the force majeure. That's why I began with the fact it's basically a contractual term. It's a contractual clause. Now, when is it a contract? Contract in the parties add item, and when they agree. But what is it they agree upon? If they agree upon something, then they have to be bound by that agreement. So if they were bound not to include something which is there in the general clause, then how can you invoke that into the force majeure clause? It is in that sense that I'm saying that as far as this issue is concerned, it has to be seen in that context, not in the context of specific triggering events, but in the context of a larger, broader, wider words which follow the specific triggering event which is over there. So if you have drafted it, and that's why I began at the outset itself, these particular clauses are very important as to how you draft them, because you have to consider all the situations which is over there and then provide for it. Not provide only the triggering event, provide also the procedure for invoking the triggering event, and also see the consequences of the triggering event, because that necessarily can avoid the contract altogether. You may not avoid the contract altogether. You may suspend it, you may delay it, you may limit it, you may perform it in a restrictive manner. It all depends on the way in which it is worded. So these are the issues which therefore have to be considered where this aspect is concerned. And while dealing with this particular issue, that's the reason why also we have to see to what extent we have to process the method by which this is to be triggered, by which it is to be invoked. How do we see it? I mean, are we going to be insistent that it has to be a condition precedent to the invocation, that the method which is stipulated must strictly be followed, or it has to be something else which has to be there? So this has to be something which has to be seen in addition. So this particular issue which I am saying about method and contemplation are essentially dealing with the general words which follow the triggering events in any case, and the triggering events in any case can be specific. And in a triggering event is specific, the effect should be either preventing, hindering, or delaying the performance. And preventing, hinder, and delay will be different, not necessarily avoiding it altogether. Avoiding it may be in any case as last resort. But whatever all this is happening, there has to be a causal link between the event and what has happened. It should be beyond the control. No, it's not a question of adjustum generis. See, there are a host of principles which are over there. In any case, so strictly speaking, the question of adjustum generis will not apply because it's not necessary that everything may be of a particular class whatsoever as far as it's concerned. There are other principles also. There are principles also of words which have to be used distributively across the contract. If one is adjustum generis, there will be nursery exercise. There will be principle of adopting what is word used and using it distributively across the contract. Now, that depends upon the word, the way in which the contract is worded. And of course, you're absolutely right. All these are tools of interpretation. Manisha is absolutely right is concerned. These are tools of interpretation is concerned. And how we construe it. Of course, as a lawyer, as a litigator, you have a job to do. You have to defend the client. But you have to defend the client in a manner which is legally permissible. And while the result may not necessarily be...
Yes.
No, so a limitation is concerned. A limitation is that we go from there are two aspects to it. Limitation under the Limitation Act, because whatever is suspended, or limitation in the sense the way the clause is worded. And when I use the word limitation, it's not in the statutory sense of Limitation Act. And so it is the cause of action. That is, limitation is concerned, when should there be a cause of action? So we got within 3 years, in 6 years, in 9 years, 12 years, ending 2 months, whatever, limitation of period. I'm not in that sense. Limitation in the sense of extending the time of performance of the contract, or saying, okay, I had 6 months to perform a particular job, I can extend it by about, say, 9 months, or I extend it by 3 months more. I give 9 months more for this particular purpose. That all depends not on the statute. That depends upon the contract, the wording of the contract, and whether you are talking about hindering, or you're talking about suspending, or you're talking about delaying the performance of the contract, and whether there's a provision at all for that. Now, if there's no provision for that, if it's not been worded accordingly, then you cannot invoke the force majeure clause. So limitation has got nothing to do with that. Limitation, the way the question is concerned, not relevant.
She's asking, can it be inserted now if it's not?
If a force majeure clause insertion, it'll be innovation, and so that will change the contract. That will require agreement of the parties in any case. Now, it's not, you cannot unilaterally do anything. Contract is always ad item. The parties have to be ad item, and there has to be agreement and consensus. That's a contract essentially agreement. Now, the point is, if there is no force majeure clause, suppose there is no force majeure clause over here. If there is no force majeure clause in any case, then in that event you can rely upon a frustration. Or there may be other clauses in the contract on which you can rely upon, because the contract is basically a composite of many different clauses, and the parties contemplate many different situations. And the situations, they can also see, there can be a price escalation clause, or there can be a period extension clause, or there can be some exemption clause which is over there. In any case, so you look at the contract itself. And you look at the contract itself, you look at the various clauses which are there in that particular contract for the purposes of seeing whether there's any other provision in the contract in which you can rely upon. And there's no provision in the contract in which you can rely upon. In this case, of course, you got the law of frustration. In any case, it's available to you. Point is, the requirements, Section 56 of the Contract Act, are satisfied. Because, as is very well known, as far as we are concerned, the principles of English law, and that is very well settled, the principles of English law possess a value only. We are governed by a Contract Act only. And the terminology of the Contract Act will prevail, and frustration will be not a question of English doctrine, a question of rule of law, as has been incorporated in the statute and actually interpreted by the courts. So, insofar as the question of insertion is concerned, that is a bilateral, that will be an agreement between the parties. But want of force majeure clause in some way will not in any way affect, because then you can fall back upon the doctrine of the doctrine of frustration or other clauses in the contract.
Yes, on that very point, if we argue frustration under 56, would not we be repudiating the contract as such? So say if one of the parties wants to continue performance of the contract, yet there is no force majeure clause, then how does Section 56 operate in that circumstance?
So force majeure clause, you see, 56 will only operate where there is no force majeure clause, and that is what the law is very clear is concerned. The law is settled, and the systems are all set. This concern, it was Satyabrata's Ghosh case. The Supreme Court had actually the Supreme Court had dealt with it, and there is one line in which in the energy watchdog case, the Supreme Court has actually, both of the submissions have been made, and one or two lines, the judgments have been sent. I think they have been over broadly stated. the arguments have been made, and also the judgment been rendered, ignores this particular distinction. Now, Satyabhata's Ghosh case specifically says this, that when there is a clause in a contract, and it will be discharged in terms of the contract itself. When it is clause, it will be discharged in terms of the contract, and then you will not look at 56 at all. You will look at the clause of the contract for the purposes of saying whether it is available at all or not. And the question which Subhendu you put to me, as far as force major is concerned, the force major will operate, as I keep saying, according to its terms. And because it operates in accordance to the terms, it's not a question of avoiding it. If it permits it to avoid it in circumstances that be avoided in terms of what the clause actually stipulates, not independent of it. But frustration is different because there's no clause. And in frustration, I have to say a supervening event which makes it either illegal or impossible, it's either legal or physical impossibility, or makes the contract qualitatively different, so as to in some way undermine the very purpose and understanding behind a particular arrangement, to make it materially different from what was originally contemplated by the parties. That is frustration. But in so force major is concerned, the parties have actually, before the event has arisen, agreed as to what would be the circumstances in which they'll be discharged of the obligation, because it is allocation of risk. It's essentially allocation of risk which is there in this particular method of contractual incorporation, wherein the parties decide as to how is it that it has to work. So the two will be very different where that is concerned. That they will work. A force majeure clause will act according to its term and tenure. A frustration will act according to whatever the principle abides, as far as 56 is concerned.
So you're talking about essential services.
No.
If government is allowed. Yes.
No, you see, let's see. Essential services, again, you're confusing two or three different things over here. Essential services will be in the list which the government has actually done to exempt them from some of the rigor of the prohibitions. Now, if it is exempted from the rigor of prohibitions, then to that extent, the prohibition will not in any way be availed for the purposes of enabling a person to take advantage of the force majeure clause, because it is exempt from it, as far as this question is concerned. Now, inability to fulfill the contract, again, the same thing comes. You have to see, first of all, and as I keep repeating the same thing, there has to be a causal link between the inability and this and the triggering event. The event should be beyond the control, which in this particular case may not be, because it is beyond. It is exempted from the limitations, and most importantly, it doesn't exempt you from the obligation if there's a possibility of the contract being performed in a way differently, but yet substantially in terms of the contractual arrangement. Then in that event, the fact that alternative method of working the contract is available will not in any way entitle you to invoke the force majeure clause itself. So all depends upon the factual scenario. All depends upon it depends on the clause, one. It depends upon the factual situation to which the clause applies, two. It depends upon how you interpret it, three. And the legal consequences will be on a case-to-case basis as to the circumstances there as presented and as incorporated in the clause. You were asking something, Shubhendu? I'm sorry, I stopped you.
No, sir. No, sir. No, sir. You can continue.
So everything, you see, all depends, and that's what I'm saying, because we have a clause. The clause has a purpose. The purpose is expressed in the content. The content has the procedure. The procedure has its consequences. The clause, the content, the procedure, the consequences have a method of interpretation. The method of interpretation has to be placed in the context. The context has to take into account the entire purpose of that particular agreement. The overarching requirement is there should not be need to dishonesty. If there's a possibility of performance in any case, notwithstanding whatever may be stated over there, that must be available. If it is available, then the question invocation of force majeure clause will not in any case avail. You have to look at the matrix of that particular situation itself for the purposes of concluding on a case-to-case basis whether the force majeure is actually applicable at all or not. So it's not something which is, you can say something, an easy heuristic or something as a rule of the thumb which can be applied mechanically or rather simplistically to what is happening over there. It has to be decided. The clause has to be drafted with intelligent care, and it has to be used with a fair amount of understanding of what the legal provisions are. Only in which case you can actually justifiably invoke the first page.
Right, sir. So we've covered a little bit of virtual hearings. We've covered force majeure clauses.
Thank you. can't hear you. I can't hear you.
Yes, sir, am I audible?
Yeah, I can hear you.
That's sorry, there was some technical glitch. So somebody had posed this question that because of virtual hearings, in future, would it be possible that lawyers who are not based in Delhi will actually, but wish to appear before the Honorable Supreme Court, would actually have this opportunity from where they operate out of their hometowns and maybe get a chance through virtual hearings to address the Honorable Supreme Court? I'll just try to relay that question as well, but in the
No,
meantime,
absolutely, absolutely. If supposing, I mean, that is the that will be the advantage of virtual hearings, that it will obviate the need of travel and save the costs of it. I was because as this topic was on a trial court as such, this discipline of the appellate court, the trial court will be different because the hearings will be different in any case, and the steps will be different. We need to have a different kind of setup for the appellate court. But yes, if the Supreme Court has a particular system, this would be one of the advantages of the system. That yes, if the system is in place, in that event, there can be a virtual hearing by a person sitting remotely at a distant location. The problem, however, here is that unlike appellate courts in, say, Canada or for that matter, South Africa, which I was just pointing out, as for that even Australia, the number of years the Supreme Court doesn't sit, all the judges don't sit together. We sit in benches. Because they sit in benches, in any case, the workload is distributed across benches. And the workload distributed across benches to have a system which will in fact cover all benches so as to accommodate everyone from different parts of the country to take part in all the multiple hearings which are taking place simultaneously in the Supreme Court, to manage the time in such a way that everyone in different parts of the country can actually take part in all the different hearings, taking different parts of the court, all before different judges, would require a feat of sorts, which will require devising of a system of with a fair amount of care. And of course, whoever will be in the charge of system designing will have to take all that into account. But yes, if we can devise a system, this will be one of the advantages the system will definitely have.
and so another thing comes about costs, whether we as a nation can actually bear the costs involved in actually having subordinate courts convert to virtual hearings. Can we actually bear those costs? That was
No,
also one of the.
actually, that's when I began. I pointed out we need to upgrade. We need to upgrade our judicial system, and there is a need, definitely a need, to allocate a larger proportion of our GDP to courts because we are understaffed in many ways, and we are overperforming. Despite the limitation and constraint system, the system is working fairly well. The naysayers and the doomsayers notwithstanding, I don't buy whatever they say. But cost is never an inhibition if the system can be efficacious, and particularly if it is for a good cause. I don't think cost would be something which should ever be considered an impediment. But talking about costs, I personally feel that there's a fair amount of improvement which the system requires, the existing system requires, rather than augmenting the system in a way to incorporate this. Incremental changes in the system to deal with the existing problems first, to address them in a manner which makes intelligent sense, would be a very important first step for this. The prohibitive nature of cost, if the efficacy can follow, which I got some, as I pointed out in the beginning itself, I got some reservation where that is concerned, not because of the technology, but because of the way in which our system is working. Mainly because the costs are prohibitive, but not in any way should not be a deterrent. In fact, there should be more payment towards this head.
This is a very thought-provoking question.
No, you see, AOR will never be eliminated because, as I said, digitization is part of the entire process, and the rules will have to be in place in any case. Yes, digitization can facilitate litigants to file too, but when the procedure is in place requiring a point person, as in the Supreme Court, the purposes of requiring some kind of authenticity and legitimacy to the court documentation, then virtual hearing, it's not a virtual hearing supplants the system. The virtual hearing integrates into the system and then adapts the system to a virtual hearing. So it's not as if the AORs will be in some extent rendered completely redundant, but the AORs will be integrated into that particular system.
That's something very personal on something different from the topics that we are discussing here. In one of the past interviews, you had mentioned that obviously you have this fondness for writing. Your blogs are very popular online. We keep reading your blogs all the time. So in one of those interviews, you mentioned that the single biggest contrast between you and your father was that you never participated, or you kept away, you maintained a distance from maybe politics, or maybe politics of the bar as such. Yet you said, as being responsible citizens, we must be intelligent observers. This is a word you had used. And so, keeping this in mind, on one hand, if we could also talk about how activism today, and in some way you had also referred that it's actually becoming a fad. So how do we draw this fine line of distinction between being an intelligent citizen, intelligent observer, and also being an activist, yet not having it converted into being a fad, just for being active, or being an activist just because it's a fad? So how do we draw that thin line of distinction?
You see, it all depends on the ethics of action. I personally feel that's all. Why is it we are acting? Do we have an ulterior motive behind it, or we have some kind of altruistic intent behind it? Are we doing it for the sake of self-aggrandizement? Are we doing it for the purpose of improvement? And what is the ideology which is motivating us? Where is it that our commitment lies? It's a commitment to a larger cause which will have an interest across. That is actually an issue. Now, the question is, how is the larger cause seen? Now, unfortunately, we are politically divided into ideologies this concern, but notwithstanding difference in political ideologies and notwithstanding whatever differences the point of view may have, a certain core issues are non-negotiable, which is concerned. Activism is very important. Activism must necessarily be motivated by ethics of propriety, which is there, keeping certain things that's utterly non-negotiable. Now, what are the things which are non-negotiable is concerned? In a country as driven like ours, unfortunately, the activists who are actually in the domain move in many ways to either slander or divide. And slander, divide, not because they are bringing truths to the fore, which can be open to criticism, but because they are in some way manipulating public opinion to a particular point of view. As long as activism is not towards manipulation and activism is bona fide for the purpose of advancing a cause, so that there can be some kind of meaningful participation and all to have a resolution of something which is in public good. I personally think activism is to be sought after and is a hallmark of an intelligent, active citizen. But unfortunately, today what I find is that as far as activists are concerned, activists have private agendas of their own, and these private agendas never come to the particular fore. And under the cloak of activism, which is given some kind of a standing of some ultimately grand act of some service, what is actually being done is you are in some way projecting and promoting ideas which can in some way affect the country's general good as such. I have got nothing against activism, I have got nothing against activists, but we have to look at whatever activism is done in individual cases dispassionately, objectively, and the activists should also be answerable to themselves as to why they are acting. So if you answer eventually the call to conscience is the only check on any kind of behavior. And as long as if we are honest with ourselves and in that private moment can actually be answerable to our conscience to in some way justify what we have done, I personally think that we'll find an answer ourselves. Activism is good, but misuse of activism is bad.
Right. So thank you so much for that answer. And another question for all our young aspirants to the bar, as well as aspiring budding judicial officers. I would just like to know on behalf of everyone that how do you prepare for cases? Is there any to-do list as to which goes in preparation, which you've been following for the last 30 years that you've been in practice? So for all our young friends here, what would you like to say to that? Preparation. You've been praised for the kind of preparation you put in and how you prepare for cases.
Well, it's not my kind of preparation. And I've been told when I was a junior lawyer and I was working my way up, my friends tell me I'll be without work, and I'll frighten the clients away and I'll frighten lawyers away. And there are lawyers also today who are in some extent diffident in coming because I am rather exacting in the way in which I work. I would not recommend this style of working at all to anyone because it's got its own pitfalls to it, and the work. It's not easy. But that said, because you've asked me this, I like to see the weakest point in my case first. This is something which I look at my weakness in the case first before I go to my strength, and I like to anticipate and outthink my opponent. Because if you steal the other person's thunder and adopt the opposite side's arguments, and in some way are prepared in advance for a question which can unsettle most, then you can approach the court with a fair amount of aggression and confidence, which can actually hold you in tough times. And what is very important is you need to have the respect of the court. We should actually believe that what we are saying has got substance, because if the court has respect for you and you are reputed to make arguments not flippantly but seriously, and what you say is taken with a fair amount of healthy respect, then no matter how difficult the bench may be and no matter how tough the matter may be, your hearing in court will be smooth, because you'll be convinced of your point and will be more or less confident of your ability to convey it. But that requires a fair amount of labor, and you cannot ever stop working or studying, and you have to be constantly aware of whatever is involved in it. And as I said, in the course of this particular thing, approach it not case wise but conceptually. You should have an idea in your head as a concept as what the matter is, and then navigate your way through it, because there's understanding, there's the clarity and understanding of the matter. Unless there's clarity understanding the matter, you cannot handle it. So don't go only to case law. Pick up law book, pick up reference books, pick up theoretical books, look at the core issue in it, and then develop an argument. And develop an argument looking at the weaknesses first. I would not recommend this. I've had a tough time in my practice, because a fair element of fear insofar as briefing is concerned, which will be shared by many people. But I'm otherwise comfortable. This is the way in which I work and enjoy working there.
There's another question from one of our young friends. He says,
Yes.
what will be the impact of virtual hearings for young lawyers? Will it lower the level of arguments in courts?
No, not at all. There's a lot of grandstanding in court, which is part of the drama of court. It makes courts a very exciting place to be in. Advocacy is performance in public. It's like a dance, a ritual, which is there, it's got its own charm. I became a lawyer for that purpose. I personally think I find this whole thing very exciting. You're pitting your bits against other and trying to come on top. That said, as a virtual hearing is concerned, that option which is there with you to have to play to galleries is to some extent obviated, because you're only in your office looking at the screen, and you have to be very business-like and serious about whatever that is concerned. Yet, yes, it is an option to senior lawyers in any case, because the fraud which is normally practiced in court about face value, and I call it a fraud generally because this is in most cases circulated by the lawyers themselves to get work, will to a large extent be affected, because you have judges, you got lawyers for judges, you got lawyers for benches over there in any case, which can, of course, which will be as real even in virtual hearings. But yes, with remote accessibility and greater access, the so-called non-entities in the lawyers, and I personally think the young lawyers these days are far better than what we were at our time. They are hardworking, sincere, and very well read. These lawyers would also will have greater access to the court, and will be at less of a disadvantage, because there will be a captive hearing between the judge and the court, and the judge would have no option but to hear. And as the lawyer, the young lawyer that he is ready and prepared, he'll have a good day in court.
I think it's been a wonderful session, sir, for all of us. Before we conclude, we would have Shri Ashok Kashyap, who is the president of our unit, the Adhivakta Parishad Delhi High Court unit, who would like to deliver the vote of thanks, sir.
हेलो अमन जी, कैसे हैं?
आप बताइए अशोक जी।
नमस्कार। नमस्कार, आप कैसे हैं?
बस एकदम ठीक. Delighted to see you. How are you?
I'm grateful that you have come and accepted our invitation. That reminds me, Bade Lekhi Saab.
जी.
You know, his memories are still lingering with me.
जी.
So we have worked together.
जी.
A great son of a great and noble lawyer, Mr. Aman Lekhi.
Definitely, he was both great and noble. You don't make lawyers like him anymore.
But he was a very versatile lawyer as well as noble as well.
Yeah, that's
because
right.
I know him. He used to always trust the truth, nothing else.
Absolutely.
So,
absolutely.
You know, we are doing this study circle. This is our first study circle on online. I will call it as a virtual study circle today.
Yes, that's true.
And hope to do more study circle like this.
You've done a very good job, sir. It's wonderful. It was a wonderful experience. I must commend you for this initiative. And I think there'll be many more such study circles. And with the sweep and the reach, it'll be definitely much better than whatever you've done up till now.
This is the teamwork of Mr. Subhendu, who has
Yes, I know. He's in
conceived this program. I said, okay,
Yes.
go ahead. I'm with you. Whatever you do, I'll accept it. So he
No,
said,
that's
Amanji is coming. Mega, very well. Mega, Amanji, I know him very since childhood, and that
yes,
will
of
be
course.
pleasure to hear him. Pleasure to hear him. You have explained everything on both of the subjects in a very well manner, and I think a lot of viewers and our lawyers will be benefited by this.
Thank you.
Therefore, I thank you on my behalf as well as on behalf of my team and Adhivakta Parishad. So that we will invite you again and again and again. This is a first virtual study circle. I also thank you to the viewers. I must thank the Subhendu, Archit, Vikrantji, and Akash, those who have taken pain to have this study circle. Thank you very much. Namaskar.
Thank you. Thank
Thank
you.
you so much. Thank you so much, Ashok sir. With
Thank
this,
you.
I think sir has already concluded, given a very good conclusion. So we were joined by a lot of viewers over the course of the last 1 hour. We had initially
Yes.
thought this was our first experiment and first attempt. We were actually unsure about how it will come out. But I think it's been fairly well received by a lot of people all over the country. And
No,
thank
it
you.
has come very well. It has come very well, and I think we must do it on an all India level.
Definitely, sir.
And the lawyers like Aman should be called again and again, and they should devote time to the cause of the lawyers as well as the cause of the subjects
Thank you.
Right.
to enhance the knowledge of all the fraternity. So I also thank you to the viewers, also those who are watching this beautiful program by Aman Lekhi.
Thank
Right.
you.
So with that, sir, we'll bring this wonderful session and informative, and I think a session full of knowledge and thoughts
Yes.
for us, be it lawyers, be it judges, be it teachers, be it professionals. And so, on behalf of the Adhivakta Parishad High Court Unit, I would like to extend our thanks, our gratitude for having taken time out of your busy schedule, because we had approached you last week with this, but in a second you gave your consent and you agreed to come on this broadcast. So, sir, this has been, I think, probably we've had the best possible speaker as our first
Certainly.
panel. And I think, sir, this will only continue, because these days everything is on the World Wide Web, because the World Wide Web is in sharp contrast to how we are actually witnessing roads outside our homes where there are no people.
Yes.
But the World Wide Web is extremely busy these days. And anyway, there are a lot of webinars that are going on. But, sir, thank you again. And on
No,
behalf
don't worry about Lacunas. Don't worry about Lacunas. You commit mistake and learn so many things.
Right. So thank you so much, sir. We were streaming live on Facebook and YouTube channels. For everyone's information, this video will be available on our respective YouTube channels as well as the Facebook page. So if anyone who has missed out will be able to view it, and this video will be there for time memorial, and we could all keep coming back and keep hearing sir again and again and again. And on behalf of everyone, sir, we take our leave. Thank you so much for having graced us this evening, sir. Thank you so much.
Thank you. Thank you very much.
Thank you all of you. Thank you all of you.